Henderson v. Morgan, Supreme Court, 1976. Justice Stevens delivered the opinion of the court. The question presented is whether a defendant may enter a voluntary plea of guilty to a charge of second-degree murder without being informed that intent to cause the death of his victim was an element of the offense. 1. On April 6, 1965, respondent killed Mrs. Ada Francisco in her home. When he was in 7th grade, respondent was committed to the Rome State School for Mental Defectives, where he was classified as retarded. He was released to become a farm laborer and ultimately went to work on Mrs. Francisco's farm. Following an argument, she threatened to return him to state custody. He then decided to abscond. During the night, he entered Miss Francisco's bedroom with a knife, intending to collect his earned wages before leaving. She awoke, began to scream, and he stabbed her. He took a small amount of money, fled in her car, and became involved in an accident about 80 miles away. The knife was found in the glove compartment of her car. He was promptly arrested and made a statement to the police. He was then 19 years old and substantially below average intelligence. Respondent was indicted for first-degree murder. Defense counsel held a series of conferences with the prosecutors, with the respondent, and with members of his family. The lawyers thought manslaughter first would satisfy the needs of justice. They therefore endeavored to have the charge reduced to manslaughter, but the prosecution would agree to nothing less than second-degree murder and a minimum sentence of 25 years. The lawyers gave respondent advice about the different sentences which could be imposed for the different offenses, but, as the district court found, did not explain the required element of intent. On June 8, 1965, respondent appeared in court with his attorneys and entered a plea of guilty to murder in the second degree in full satisfaction of the first-degree murder charge made in the indictment. In direct colloquy with the trial judge, respondent stated that his plea was based on the advice of his attorneys, that he understood he was accused of killing Mrs. Francisco in Fulton County, that he was waiving his right to a jury trial, and that he would be sent to prison. There was no discussion of the elements of the offense of second-degree murder, no indication that the nature of the offense had ever been discussed with respondent, and no reference of any kind to the requirement of intent to cause the death of the victim. At the sentencing hearing a week later, his lawyers made a statement explaining his version of the offense, particularly noting that respondent meant no harm to that lady when he entered the room with the knife. After studying the probation officer's report, the trial judge pronounced sentence. At the evidentiary hearing, where respondent challenged his plea, he testified that he would not have pleaded guilty if he had known that an intent to cause the death of his victim was an element of the offense of second-degree murder. The district judge did not indicate whether or not he credited this testimony. 2. We assume, as petitioner argues, that the prosecutor had overwhelming evidence of guilt available. Nonetheless, such a plea cannot support a judgment of guilt unless it was voluntary in a constitutional sense, and clearly the plea could not be voluntary in the sense that it constituted an intelligent admission that he committed the offense unless the defendant received real notice of the true nature of the charge against him, the first and most universally recognized requirement of due process. The charge of second-degree murder was never formally made. Had it been made, it necessarily would have included a charge that respondent's assault was committed with a design to effect the death of the person killed. An admission by respondent that he killed Mrs. Francisco did not necessarily also admit that he was guilty of second-degree murder. There is nothing in this record that can serve as a substitute for either a finding after trial or a voluntary admission that respondent had the requisite intent. Defense counsel did not purport to stipulate to that fact. They did not explain to him that his plea would be an admission of that fact, and he made no factual statement or admission necessarily implying that he had such intent. In these circumstances, it is impossible to conclude that his plea to the unexplained charge of second-degree murder was voluntary. Normally, the court contains either an explanation of the charge by the trial judge or at least a representation by defense counsel that the nature of the offense had been explained to the accused. Moreover, even without such an express representation, it may be appropriate to presume, in most cases, defense counsel routinely explain the nature of the offense in sufficient detail to give the accused a notice of what he is being asked to admit. This case is unique because the trial judge found as a fact that the element of intent was not explained to respondent. Moreover, respondent's unusually low mental capacity provides a reasonable explanation for counsel's oversight. It also forecloses the conclusion that the error was harmless beyond a reasonable doubt, for it lends at least a modicum of credibility to the defense counsel's appraisal of the homicide as a manslaughter rather than a murder. Since respondent did not receive adequate notice of the offense to which he pleaded guilty, his plea was involuntary and the judgment of conviction was entered without due process of law.